I caught HOA Karen hunting ducks from my family's blind. I inherited 6,400 acres expecting to honor my father's legacy, not defend it. But before the sun came up, I found HOA President Brenda Collins hunting ducks from my family's blind, standing on land she'd calmly claimed belonged to her neighborhood. She had maps, permits, and years of confidence behind her. I had one recorded deed. What I uncovered next exposed a lie that had been growing for nearly a decade, and by the time it reached a courtroom, nothing was what the HOA said it was. If you enjoy real stories about land, law, and standing your ground the right way, take a second to subscribe. Now let me show you how a quiet Wyoming marsh became the center of a fight nobody saw coming. I inherited 6,400 acres 3 weeks after my father was buried. Most people heard that number and imagined wealth. They pictured endless pasture, oil leases, or cattle spread across the horizon. What my father left me was something different. He left responsibility. Every fence line, every creek crossing, every cottonwood grove, every acre of marsh carried decades of decisions that someone had made before I was old enough to understand why they mattered. After 30 years working as a county water resources engineer, I had read enough surveys, drainage maps, and boundary plats to know one thing. Land remembers, people forget. The Mercer Ranch stretched across eastern Wyoming where sandstone ridges slowly fell into a broad marsh that my grandfather had refused to drain long before anyone talked about wildlife conservation. He used to tell me that water always found its way home if people were patient enough to let it. That marsh had belonged to our family longer than I had been alive. The morning everything changed. I left the ranch house well before sunrise, carrying nothing more than a thermos of coffee and an old pair of binoculars. I wanted to check the duck blind my father and I had rebuilt nearly 20 years earlier. Duck season had opened the previous weekend, but I hadn't invited anyone onto the property yet. The cold bit through my jacket as I crossed the pasture. Cottonwoods lined the edge of the basin, their leaves nearly gone. Beyond them, cattails formed a dense wall around still black water that reflected the fading stars. Then I heard the first shotgun blast. It echoed across the marsh. A second shot followed almost immediately. I stopped walking. Nobody should have been hunting there. Not this morning. Not ever without my permission. I moved through the reeds until I reached the edge of the clearing where the old wooden blind overlooked open water. 3 people stood exactly where my father had stood every October for decades. Decoys floated across the marsh in neat rows. A Labrador retriever waited beside the blind. 2 men in camouflage were reloading their shotguns, while a woman in expensive insulated boots watched ducks circle overhead. An ATV sat nearby. Its side panel carried the green and gold logo of Timber Ridge Estates. The machine was parked beside one of the old Mercer boundary markers, a weathered cedar post topped with a rusted brass survey cap that had marked our property line for years before Timber Ridge Estates even existed. The woman turned when she heard my boots. She looked me over once before speaking. "You'll need to stay behind the marker," she said. "Residents are hunting this section this morning." She wasn't asking. She was giving instructions. "I'm Daniel Mercer," I replied evenly. "You're standing on Mercer Ranch." She smiled with practiced confidence. "Brenda Collins." She didn't offer a handshake. "I'm president of Timber Ridge Estates." She gestured toward the marsh as though introducing me to something she owned. "This is our protected community waterfowl area. Residents have scheduled access during hunting season." One of the hunters nodded in agreement without lowering his shotgun. "We've been coming here for years." I looked from Brenda to the blind. The cedar boards still carried the initials my father had carved with his pocket knife when I was a teenager. The storage shelf inside still held the coffee can where we kept extra shells. Even the weathered bench was ours. Nothing about this place belonged to Timber Ridge. "I don't think you understand," I said. "No," Brenda interrupted. "I think you don't understand." She opened a leather folder and removed several laminated pages. "The HOA manages this conservation area. If you've recently purchased adjacent land, I'm sure someone forgot to explain the community access agreement. Recently purchased. I almost laughed. Instead, I took out my phone. Without another word, I photographed the ATV, then the Timber Ridge logo, then the hunters, their shotguns, their decoys, the dog, the cedar boundary marker. Finally, I photographed Brenda herself still holding the laminated papers. "What exactly are you doing?" she asked. "Keeping records." Her expression hardened. "You'll want to stop interfering with HOA hunting privileges." "I appreciate the advice." "You have 72 hours to remove any personal equipment from this blind." She pointed directly behind her. "It belongs to the community." I simply nodded. Then I turned around and walked back toward the ranch house. Behind me, I heard another shotgun blast. Nobody followed. Nobody stopped me. An hour later, I unlocked my father's office for the first time since the funeral. The room looked exactly as he'd left it. County maps covered one wall. Metal filing cabinets lined another. On the desk sat a row of carefully labeled archival boxes. One label caught my attention. Timber Ridge Development. Inside was a thick county survey file. The very first document was the recorded subdivision approval. Across the top, in bold county lettering, was the filing date. Timber Ridge Estates had been legally created 18 years after the Mercer family recorded ownership of the Marsh. I stared at the date for several seconds. I inherited 6,400 acres 3 weeks after my father was buried. Most people heard that number and imagined wealth. They pictured endless pasture, oil leases, or cattle spread across the horizon. What my father left me was something different. He left responsibility. Every fence line, every creek crossing, every cottonwood grove, every acre of marsh carried decades of decisions that someone had made before I was old enough to understand why they mattered. After 30 years working as a county water resources engineer, I had read enough surveys, drainage maps, and boundary plats to know one thing: land remembers. People forget. The Mercer Ranch stretched across eastern Wyoming, where sandstone ridges slowly fell into a broad marsh that my grandfather had refused to drain long before anyone talked about wildlife conservation. He used to tell me that water always found its way home if people were patient enough to let it. That marsh had belonged to our family longer than I had been alive. The morning everything changed. I left the ranch house well before sunrise, carrying nothing more than a thermos of coffee and an old pair of binoculars. I wanted to check the duck blind my father and I had rebuilt nearly 20 years earlier. Duck season had opened the previous weekend, but I hadn't invited anyone onto the property yet. The cold bit through my jacket as I crossed the pasture. Cottonwoods lined the edge of the basin, their leaves nearly gone. Beyond them, cattails formed a dense wall around still black water that reflected the fading stars. Then I heard the first shotgun blast. It echoed across the marsh. A second shot followed almost immediately. I stopped walking. Nobody should have been hunting there. Not this morning. Not ever without my permission. I moved through the reeds until I reached the edge of the clearing, where the old wooden blind overlooked open water. 3 people stood exactly where my father had stood every October for decades. Decoys floated across the marsh in neat rows. A Labrador retriever waited beside the blind. 2 men in camouflage were reloading their shotguns, while a woman in expensive insulated boots watched ducks circle overhead. An ATV sat nearby. Its side panel carried the green and gold logo of Timber Ridge Estates. The machine was parked beside one of the old Mercer boundary markers, a weathered cedar post topped with a rusted brass survey cap that had marked our property line for years before Timber Ridge Estates even existed. The woman turned when she heard my boots. She looked me over once before speaking. "You'll need to stay behind the marker," she said. "Residents are hunting this section this morning." She wasn't asking. She was giving instructions. "I'm Daniel Mercer," I replied evenly. "You're standing on Mercer Ranch." She smiled with practiced confidence. "Brenda Collins." She didn't offer a handshake. "I'm president of Timber Ridge Estates." She gestured toward the marsh, as though introducing me to something she owned. This is our protected community waterfowl area. Residents have scheduled access during hunting season. One of the hunters nodded in agreement without lowering his shotgun. We've been coming here for years. I looked from Brenda to the blind. The cedar boards still carried the initials my father had carved with his pocket knife when I was a teenager. The storage shelf inside still held the coffee can where we kept extra shells. Even the weathered bench was ours. Nothing about this place belonged to Timber Ridge. I don't think you understand, I said. No, Brenda interrupted. I think you don't understand. She opened a leather folder and removed several laminated pages. The HOA manages this conservation area. If you've recently purchased adjacent land, I'm sure someone forgot to explain the community access agreement. Recently purchased. I almost laughed. Instead, I took out my phone. Without another word, I photographed the ATV, then the Timber Ridge logo, then the hunters, their shotguns, their decoys, the dog, the cedar boundary marker. Finally, I photographed Brenda herself still holding the laminated papers. What exactly are you doing? She asked. Keeping records. Her expression hardened. You'll want to stop interfering with HOA hunting privileges. I appreciate the advice. You have 72 hours to remove any personal equipment from this blind. She pointed directly behind her. It belongs to the community. I simply nodded. Then I turned around and walked back toward the ranch house. Behind me, I heard another shotgun blast. Nobody followed. Nobody stopped me. An hour later, I unlocked my father's office for the first time since the funeral. The room looked exactly as he'd left it. County maps covered one wall. Metal filing cabinets lined another. On the desk sat a row of carefully labeled archival boxes. One label caught my attention. Timber Ridge Development. Inside was a thick county survey file. The very first document was the recorded subdivision approval. Across the top, in bold county lettering, was the filing date. Timber Ridge Estates had been legally created 18 years after the Mercer family recorded ownership of the marsh. I stared at the date for several seconds. Then I reached for my phone. It was time to call a lawyer. Laura Bennett answered on the second ring. I was wondering when I'd hear from a Mercer again, she said. Her voice was calm, steady, the kind that didn't waste words. She had handled property disputes across 3 Wyoming counties for more than 25 years and had represented my father twice in minor boundary matters long before I inherited the ranch. I need you to come to the house, I said. I've got company. An hour later, she was standing over my father's desk, reading the subdivision file while I laid out the photographs from the marsh. She studied each one without speaking. Brenda Collins, the hunters, the ATV, the Mercer boundary marker, the duck blind. When she finished, she slid the photographs into a neat stack. They're using your blind, she said, like they've always owned it. They acted like I was trespassing. Laura nodded once. Let's find out what they think gives them that confidence. She opened the Timber Ridge Estates subdivision records my father had preserved decades earlier. The original county plat showed every recorded lot, every road, every drainage easement, and every common area inside the development. The southern property line ended nearly 3/4 of a mile north of my marsh. There was no question. The subdivision simply stopped. My land began. Laura traced the boundary with the eraser of her pencil. Now let's find the easements. She spent another 20 minutes comparing county plats against the recorded deeds. There was exactly one, a narrow utility corridor crossing the northeastern corner of Mercer Ranch, 20 feet wide, restricted to underground electrical maintenance, no vehicle access, no hunting rights, no recreational use, no marsh. Laura leaned back. So far, they don't have anything. 3 days passed quietly. Then a certified envelope arrived. The return address read, Timber Ridge Estates Homeowners Association. Inside was a formal violation notice signed by Brenda Collins. According to the letter, I had interfered with authorized community hunters, removed HOA wildlife management signs, blocked access to a protected natural amenity, and violated what Brenda described as a long-standing recreational easement. The final paragraph demanded that I surrender the keys to the Marsh gate and remove every private property sign within 10 days. Failure to comply, it warned, would result in escalating penalties and legal action. Laura read that letter once, then again. "This isn't written by someone who understands property law," she said. "It's written by someone who assumes no one will question it." Attached behind the notice was a full-color map. At first glance, it looked official: roads, lot numbers, walking trails, community amenities shaded in green. The marsh appeared as part of a large conservation area labeled Timber Ridge Community Waterfowl Preserve. Laura frowned. "Something's wrong." She spread the HOA map beside the official county plat. The differences jumped out immediately. The county survey carried the surveyor's seal, recording number, filing date, legal descriptions, and certified bearings. The HOA map carried none of them. No seal, no recording information, no survey certification, no county approval. It wasn't a recorded plat. It was a graphic illustration. Yet the green boundary swallowed nearly 900 acres of Mercer Ranch. Laura pointed to the lower corner. "See this?" Tiny print read, "Prepared for community information only, not a recorded survey." I looked back at Brenda's violation letter. She had attached an unofficial brochure map, as if it carried legal authority. "Can they actually do that?" I asked. "They can print anything they want." Laura folded the HOA map in half. "They just can't turn fiction into ownership." She opened another folder my father had labeled Subdivision Correspondence. Inside were nearly 20 years of newspaper clippings, county notices, and public meeting agendas involving Timber Ridge estates. One newsletter caught her attention. Its cover featured families kayaking beside a photograph of my marsh. The caption underneath read, "Enjoy Timber Ridge's protected wetlands all year long." Laura slowly lowered the paper. This wasn't an accident. She laid the newsletter beside Brenda's map. "They've been teaching residents this marsh belongs to the HOA for years." For a long moment, neither of us spoke. This wasn't a simple boundary dispute anymore. Someone had created an entirely different version of reality, and hundreds of homeowners had apparently believed it. Laura closed the file. "I think we just found the beginning of your case." The next morning, I started building the record. I photographed every Mercer boundary marker between the ranch road and the marsh. I logged the coordinates, the condition of each post, and the distance from the Timber Ridge property line. I copied my father's tax receipts, old hunting leases, and maintenance records for the blind. Then I called Walter Hayes. Walter had owned the neighboring ranch for 38 years. He had watched Timber Ridge rise from empty pasture into rows of expensive homes with stone entrances and artificial ponds. When I showed him Brenda's map, he stared at it for a long time. "That's not the county line," he said. "I know." He tapped the green section covering my marsh. "I've seen their people down there every fall." "How long?" 8 years, maybe 10. That stopped me. Walter explained that hunters arrived with laminated Timber Ridge permits clipped to their jackets. Some came in HOA-marked ATVs. Others were escorted through the northern gate by board members. "I assumed your father had worked something out with them," he said. "They carried themselves like they had permission." My father would have documented any agreement. There was none. Laura sent a formal demand to every Timber Ridge board member. She required them to produce the alleged recreational easement, hunting agreements, insurance policies, board minutes, access permits, and all money collected from anyone using the marsh. They had 14 days. The board did not respond. On the 16th day, a dark pickup stopped beside my equipment shed. The driver was Kevin Brooks, Timber Ridge's treasurer. He kept looking toward the ranch road, as if he expected someone to follow him. "I can't stay long," he said. He handed me a thick envelope. Inside were financial statements, hunting pass forms, and copies of HOA deposit records. The first permit was labeled Premium Marsh Hunting Access. The annual price was $750 for residents. Outside guests paid as much as $1,500 per season. Some permits included priority blind reservations and ATV access. There were dozens of names. "This has been going on for years," Kevin said. Did Brenda create it?" "She controls it." He pointed to a recreation account in the statements. Hunting pass payments had been deposited there, but several withdrawals were marked only as community promotion, hospitality, or special outreach. No receipts were attached. "How much money are we talking about?" I asked. Kevin swallowed. "More than $80,000 that I can verify." Laura arrived 20 minutes later and reviewed the records at my kitchen table. The permits used photographs of my marsh. The brochures called it an exclusive Timber Ridge amenity. One sales packet promised homebuyers private seasonal access to some of the best waterfowl habitat in the county. This wasn't a misunderstanding. The HOA had been selling what it did not own. Kevin opened his phone and forwarded several board emails. In one exchange, another board member had asked Brenda to provide the deed or easement supporting the hunting program. Brenda's reply was short. Laura read it aloud. "The Mercer family has never challenged us. After enough years, access becomes ours." The room went silent. That sentence changed everything. Brenda knew there was no deed. She knew there was no recorded easement. She had simply counted on my family staying quiet long enough for her claim to harden into fact. Laura printed the email and placed it on top of the file. "Now we know what she believed she was building," she said. I looked at the permits spread across my father's table. Brenda had sold access to my land. She had used my family's marsh to raise property values, reward selected residents, and strengthen her own position inside Timber Ridge. And now she had put her plan in writing. Laura didn't waste a day. By the following afternoon, she had prepared a 12-page cease and desist package addressed to Brenda Collins and each member of the Timber Ridge board individually. Every envelope contained the same evidence: certified copies of the Mercer deed, the recorded county plat, the certified boundary survey, historic property tax records, photographs of Mercer Ranch boundary posts, copies of the premium hunting permits, Brenda's email about waiting long enough for access to become theirs. The final page was direct. Any future entry onto Mercer Ranch without written permission would be treated as intentional trespass. Any damage to gates, fences, blinds, or other improvements would be documented and pursued through both civil remedies and any applicable criminal statutes. Laura sent every package by certified mail. "I don't want anyone claiming they never saw it," she said. Within a week, every green return receipt came back signed. Brenda Collins signed hers personally. So did every board member. Laura placed the receipts into a new binder. "From this point forward," she said, "every decision they make is an informed one." For 3 days, nothing happened. Then Walter Hayes called just after sunrise. "They're gathering at the clubhouse," he said. "More trucks than I've seen in a long time." By noon, Kevin Brooks sent a short text. "Emergency HOA meeting. Brenda says you're trying to steal community land." An hour later, another message arrived. "She's telling residents to defend their rights." Laura read both messages. "Keep every one of them." Saturday morning began with the sound of engines. Not one, several. I stepped onto the porch and watched a line of pickups and ATVs turn off the county road toward the marsh access. There were 6 hunters, 2 HOA board members, a flatbed trailer carrying utility equipment. Brenda Collins rode in front. She climbed off her ATV holding the same laminated amenity map she'd shown me days earlier. The maintenance worker unloaded a pair of large bolt cutters. They walked straight toward my locked gate. I didn't move. I'd already made one phone call before leaving the house. Sheriff Mark Dalton told me he was on his way. Brenda stopped a few feet from the chain stretched across the entrance. "You've had plenty of time to remove this obstruction," she announced loudly enough for everyone to hear. "This road belongs to Timber Ridge residents." "It doesn't," I replied. She ignored me. "Cut it." The maintenance worker lifted the bolt cutters. Before the jaws closed around the chain, another truck rolled onto the road behind the group. Sheriff Mark Dalton stepped out wearing his county jacket. Everyone froze. He looked first at the chain, then at the bolt cutters. Finally, at Brenda. "Morning," he said evenly. Brenda smiled with obvious relief. "Sheriff, perfect timing. This landowner is illegally blocking HOA property." She unfolded the laminated map and handed it to him. "Our residents have lawful access." Sheriff Dalton studied it for less than 10 seconds. Then he looked up. "Where's the county recording number?" Brenda hesitated. "This is our official community map." "I didn't ask that." He held the paper between two fingers. "Where is the county recording number?" Silence. "There isn't one," Brenda admitted. Sheriff Dalton handed that map back. I removed a tube from my truck and unrolled the certified boundary survey Laura had prepared. The sheriff compared both documents side by side. The difference was impossible to miss. The HOA map pushed the southern boundary nearly 3/4 of a mile into Mercer Ranch. The certified survey matched the county records exactly. Sheriff Dalton rolled up the survey and handed it back to me. "This property belongs to Daniel Mercer." He turned toward the maintenance worker. "Put the bolt cutters away." Then he faced Brenda. "You've received written notice that this land is disputed and that Mr. Mercer claims ownership supported by recorded documents." "It isn't disputed," I said quietly. "It's recorded." The sheriff nodded. "Either way, nobody is cutting this gate today." Brenda's face tightened. "Our residents have hunted here for years." "That may be," Sheriff Dalton replied, "but habit isn't a deed." He looked around at the assembled hunters. "You've all been asked to leave private property." One by one, the hunters lowered their eyes. Nobody argued. Nobody reached for the chain again. Before returning to his truck, the sheriff looked directly at Brenda. "If anyone comes back after today's warning and damages this property, we'll be having a very different conversation." The convoy slowly turned around. Engines faded toward Timber Ridge. The marsh became quiet again. I stood beside the untouched chain while ducks circled overhead without landing. For the first time since inheriting the ranch, I realized Brenda hadn't just tried to take my family's marsh. She had convinced an entire community that my boundary no longer existed. The sheriff's warning should have ended the dispute. Instead, it escalated it. 5 days later, a process server drove through my front gate and handed me a thick envelope. Timber Ridge Estates Homeowners Association had filed suit in County District Court. Brenda's complaint claimed the HOA had acquired permanent recreational rights through decades of continuous public use. She argued the marsh had become an implied community amenity, that residents had relied on access when purchasing their homes, and that closing the gate had caused financial harm to the association. The final page asked the court to order me to reopen the marsh immediately. I drove straight to Laura's office. She finished reading the complaint, closed the folder, and smiled for the first time since this began. This is exactly what she wanted. To sue me? To move the fight away from recorded facts and toward public expectations. She pulled a yellow legal pad closer. "So we'll bring it back to the documents." By the end of the afternoon, Laura had filed our response. We denied every ownership claim. Then came the counterclaim: trespass, fraudulent misrepresentation, unjust enrichment, property damage, recovery of legal fees, a permanent injunction preventing the HOA from entering Mercer Ranch again. "This case isn't just about keeping them out," Laura said. It's about proving they knew they had no right to come in. Discovery began 2 weeks later. The court ordered Timber Ridge to produce internal emails, meeting minutes, financial records, marketing materials, and every document supporting Brenda's claim that the Marsh belonged to the HOA. Boxes started arriving. Most contained exactly what Laura expected: newsletters, meeting agendas, resident notices, brochures showing families kayaking and hunting on my marsh. But one production changed everything. Buried inside years of board correspondence were repeated questions from other directors. Can someone provide the recorded easement? Has legal confirmed ownership? Should we stop advertising the marsh until title is verified? Every answer came from Brenda. Every answer avoided the question. One email read, "Removing the marsh from our materials would reduce property values. Continue using the existing map until further notice." Laura highlighted the sentence. "That's knowledge." Another message warned Brenda that the county plat did not match the HOA brochure. She replied only minutes later. "The residents believe the brochure. Don't create unnecessary confusion." Laura looked across the conference table. She's no longer claiming she was mistaken. A week later, Walter Hayes arrived carrying a cardboard tube. Inside were photographs dating back nearly 15 years. Every picture showed Mercer boundary posts standing exactly where they stood today. Some included my father repairing fences. Others showed leased hunters posing beside posted private property signs. Each photograph carried a printed date. Each one destroyed the HOA's claim that the marsh had ever been openly surrendered to public use. "My wife insisted on dating every photo," Walter said quietly. "I guess that habit finally paid off." Before he left, I thanked him. "You don't owe me thanks," he replied. "I owe your father the truth." The final breakthrough came from Kevin Brooks. He agreed to testify. Not because Laura pressured him, because he was tired of signing financial reports that no longer matched his conscience. He brought another folder. This one contained premium hunting pass applications issued not only to homeowners, but to real estate investors, developers, and several county business leaders. Each permit carried Brenda's signature. Some included handwritten notes: VIP access, investor guest, priority reservation. Laura spread the permits across the table beside the revenue ledger. Brenda hadn't been protecting a neighborhood tradition. She had been selling exclusivity. She used my family's marsh to attract buyers, reward influential contacts, and strengthen her own position inside Timber Ridge. The lawsuit she believed would force me into surrender had done the opposite. It had opened every locked cabinet she had spent years trying to keep closed. The courtroom was full before the hearing even began. Several Timber Ridge homeowners filled the back rows. Some had purchased hunting passes. Others had bought homes believing the marsh was a permanent community amenity. Their expressions weren't hostile anymore. They looked uncertain. Judge Elaine Carter entered exactly on time. "This matter concerns competing claims of property ownership and recreational access," she said. "The court will decide those claims based on recorded evidence, not assumptions." Brenda sat beside her attorney, without looking in my direction. When the HOA presented its case, the strategy became clear. Their attorney argued that residents had relied on the marsh for years, that generations of homeowners believed it belonged to Timber Ridge, and that removing access would reduce property values and disrupt the community. Then he placed Brenda's familiar laminated amenity map on an easel. "This map has guided the association for years," he said. Judge Carter adjusted her glasses. "Was this document ever recorded with the county?" "No, Your Honor." "Was it prepared by a licensed surveyor?" "No." "Does it contain a legal description of the property?" "It does not." She made a note. "Did Daniel Mercer's father ever sign an agreement dedicating this marsh to the association?" The attorney paused. "No." "Very well." Laura stood. "Your Honor, the defense would like to discuss documents that were actually recorded." She began with the Mercer deed, then the original county subdivision plat. Next came the certified boundary survey prepared by a licensed surveyor. She introduced decades of county tax records showing the Mercer family had continuously paid taxes on every acre of the marsh. Then came dated photographs from Walter Hayes, boundary posts, private property signs, my father repairing fences, leased hunters standing beside posted warning signs stretching back years before Timber Ridge claimed public access. Walter testified next. "I've lived beside the Mercer Ranch for 38 years, he said. The boundary never moved. The signs never disappeared." Laura then called Kevin Brooks. The courtroom became noticeably quieter. Kevin identified himself as Timber Ridge's treasurer and confirmed that Brenda personally supervised the Premium Hunting Pass program. He authenticated the financial records, the deposits, the brochures, the investor passes. Finally, Laura displayed Brenda's internal emails. One after another appeared on the courtroom screen. Questions from board members asking for proof of ownership. Warnings that the county plat did not match the HOA brochure. Brenda's responses refusing to remove the marsh from marketing materials. Then Laura projected the sentence that had started appearing in every conversation since discovery. "The Mercer family has never challenged us. After enough years, access becomes ours." No one spoke. Laura walked toward the easel. "Your Honor, permission to display Defense Exhibit 27. Judge Carter nodded. Laura placed the certified county survey beside Brenda's laminated HOA map. The difference was impossible to ignore. The official survey ended exactly where Mercer Ranch began. The HOA brochure pushed its southern boundary nearly 3/4 of a mile into my family's recorded property. The judge stepped down from the bench to examine both documents herself. She studied them silently for nearly a minute. When she returned to her seat, she looked directly at Brenda. "Mrs. Collins, did you know these maps were different?" Brenda hesitated. "I believed the community map reflected historical use." "That wasn't my question." Another pause. "Yes." The courtroom remained completely still. Judge Carter folded her hands. "The law recognizes deeds, recorded plats, surveys, and lawful easements. It does not recognize repeated mistakes simply because they have been repeated for many years." She began reading her ruling. "The HOA possessed no ownership interest in the Mercer Marsh. It possessed no recreational easement, no implied dedication, no hunting rights, no authority to enter the property. Every claim filed against me was dismissed with prejudice." Then she turned to Laura's counterclaim. The court granted a permanent injunction prohibiting Timber Ridge Estates from entering Mercer Ranch without permission. The HOA was ordered to reimburse all documented legal fees and property damages, repay revenue collected from the unauthorized hunting pass program, notify every homeowner that the marsh was private property, remove every brochure, website reference, and map identifying it as a community amenity, and provide a complete list of everyone who had purchased access. Finally, Judge Carter looked toward the clerk. "I am also referring the financial records introduced today to the appropriate authorities for further review." Brenda lowered her eyes. For the first time since I had met her beside the marsh, she had nothing left to argue. The record had spoken, and the record had won. By the following week, the judgment had already begun changing Timber Ridge. Brenda Collins never attended another board meeting. Instead, every homeowner received a formal notice that she had resigned as HOA president, effective immediately. No explanation, no statement defending the hunting program, no claim that the court had misunderstood the facts. She simply disappeared from the position she had spent years using to convince people that confidence mattered more than documentation. Kevin Brooks called me 2 days later. "It's over," he said. "Not completely," I replied. "No," he admitted. "But the board finally knows what really happened." The newly appointed directors requested copies of the court order before holding their first meeting. For the first time, they compared the certified county plat With the HOA amenity map Brenda had circulated for years, there wasn't much to debate. The false boundary had never existed outside Timber Ridge's own publications. Within a month, every reference to the Mercer Marsh disappeared from the HOA website. The glossy brochures promising private hunting access were withdrawn. Community entrance maps were replaced. Printed newsletters were corrected. Letters went to every homeowner explaining that the marsh had always been privately owned and that the association had no authority over it. Another mailing went to everyone who had purchased premium hunting passes. The HOA informed them the program had been unauthorized and that refunds would be issued under the court's order. Several residents stopped by the ranch over the following weeks. Most weren't angry. They were embarrassed. One older couple apologized for walking the marsh years earlier after reading an HOA brochure. A young family admitted they had purchased their home believing the wetlands were part of the neighborhood. I told each of them the same thing. You relied on what you were told. That wasn't the same as creating the lie. Walter Hayes arrived one Saturday morning carrying a bundle of freshly cut cedar posts. Thought these would last longer than the old ones. Together, we replaced every weathered boundary marker leading toward the marsh. We measured each location against the certified survey, set every post straight, and fastened new private property signs beneath them. There wasn't any anger left in the work, only satisfaction that the line now matched the record everyone had finally seen. Laura visited a few days later with copies of the final filings showing the injunction had been entered permanently. She handed me the folder. "Keep this where your father kept the rest." I smiled. I think he'd approve. I think he expected you'd need it someday. As winter gave way to spring, conservation volunteers helped repair damaged sections of shoreline vegetation where repeated ATV traffic had worn deep ruts through the marsh edge. We reinforced the duck blind instead of replacing it. Its old cedar boards carried too much history to throw away. The goal wasn't to erase the past. It was to preserve what had always belonged there. Months later, before sunrise, I walked the same trail I'd taken on my first morning back at the ranch. The gate stood closed. Its chain was intact. Fresh cedar posts marked the boundary with quiet certainty. No ATV tracks crossed the pasture. No laminated permits fluttered from dashboards. No voices claimed community authority over someone else's land. Only mallards settled onto calm water, while reeds moved gently in the morning breeze. I sat inside the old family blind and watched the first light spread across the marsh. My grandfather had protected it. My father had documented it. I had defended it. Not with threats. Not with shouting, with records, with patience, with the truth. Brenda had possessed letterhead, meetings, glossy maps, years of confident repetition, and the influence that came with her office. I had one recorded deed. In the end, that single document proved stronger than every story built to replace it, because ownership is never established by repetition. It is established by the record. And once the record was finally allowed to speak, the marsh became exactly what it had always been. Home. I thought the case had ended with the judge's ruling. Legally, it had, but the consequences continued unfolding in ways no court order could force. About a month after the injunction became final, Laura called with an update. The county finished reviewing the documents we submitted. What did they find? Nothing that changes your ownership. She paused. But they are asking Timber Ridge for additional financial records related to the hunting pass program. I wasn't surprised. The court had already seen enough to question where the money had gone. Now the county wanted complete accounting records covering every season Brenda had managed the program. Laura slid a copy of the court's final judgment across my kitchen table. "From this point forward," she said, "every future board inherits this order. No president can simply ignore it." That mattered more than any headline. The ruling didn't just protect me. It protected the land long after everyone involved in the lawsuit was gone. A few weeks later, Kevin Brooks stopped by the ranch again. This time he wasn't carrying boxes, only a single folder. The new board asked me to deliver this. Inside were copies of resolutions unanimously adopted at Timber Ridge's first meeting under its new leadership. The HOA formally acknowledged that the Mercer Marsh had never been association property. Every version of the unofficial amenity map had been withdrawn. Future promotional materials would rely only on recorded county surveys. Any proposed recreational feature would require documented ownership before appearing in marketing. I looked up at Kevin. That's a very different board. It had to become one. He hesitated before continuing. You know what surprised everyone? What? Nobody ever asked Brenda to produce the deed. The room grew quiet. For years, residents had trusted newsletters, brochures, meetings, and confident speeches. Very few had asked the simplest question of all. Who actually owns the land? That answer had been sitting in the county recorder's office the entire time. Walter Hayes laughed when I told him. Funny how truth works. How's that? It doesn't get stronger because more people repeat it. He tapped one of the new cedar posts standing beside the fence. It just waits. As spring settled across the ranch, I invited a local conservation group to inspect the marsh. Instead of discussing lawsuits, we talked about nesting habitat, invasive weeds, and shoreline restoration. They recommended several improvements that would benefit migrating waterfowl without changing the character of the wetland my grandfather had protected decades earlier. For the first time since returning home, every conversation focused on the future instead of the dispute. One afternoon, a family from Timber Ridge stopped at the front gate. The father introduced himself, then handed me a folded brochure. It was one of Brenda's old promotional packets showing families hunting on my marsh. I almost threw this away, he said. Then I realized my kids should see it. He pointed toward the corrected county map folded inside his jacket, so they'll understand the difference between advertising and ownership. I accepted the brochure, not as evidence anymore, as a reminder. Documents can reveal the truth, but they can also hide it when people stop asking where they came from. That evening, I locked the brochure inside my father's filing cabinet beside the court order, the certified survey, and the Mercer deed. All of them told the same story. Only one of them had always been true. The difference was that now everyone knew which one it was. 3 months after the hearing, Laura called me back to her office. A county investigator had completed the first review of Timber Ridge's recreation account. The report did not accuse every board member of wrongdoing. Most had approved budgets based on summaries Brenda provided. But the hunting pass revenue was another matter. The investigators confirmed that Brenda had collected more than $80,000 for access to land the HOA never owned. Some of that money had paid ordinary association expenses. Other withdrawals lacked invoices, board authorization, or any clear community purpose. The county had not finished deciding what action to take against Brenda personally. The court's financial orders, however, were already enforceable. Timber Ridge had to repay every documented hunting pass fee. It also had to reimburse me for the damaged gate hardware, repairs to the Marsh Road, legal expenses, survey costs, and habitat restoration tied to unauthorized access. Laura placed a proposed payment schedule in front of me. The new board wants to resolve this without an appeal. Are they accepting the judgment? They're accepting the record. That was enough. The HOA's insurance carrier covered part of the legal costs, but it refused to protect Brenda from conduct she had knowingly continued after receiving written warnings. The remaining expenses would come from Timber Ridge's reserve account and a special assessment approved by the new board. Residents were furious. This time, they were not angry with me. At the next open HOA meeting, Kevin read Brenda's emails aloud. Homeowners learned that she had ignored questions about the deed, ordered the false map to remain in circulation, and kept selling access after being warned that the county records contradicted her. One resident stood and held up a premium hunting pass. "You charged me $1,200 for trespassing. Another displayed the brochure used when his family bought their home. You sold us a promise you never had the right to make. Brenda did not attend. Her attorney submitted a written statement claiming she had acted for the community's benefit. The board rejected it. Good intentions did not explain forged boundaries, hidden warnings, or money collected after the truth was known. Within weeks, refund checks went out. The HOA also mailed formal corrections to real estate agents, investors, and former residents who had received the false amenity map. Every letter included the same sentence: the Mercer Marsh is private property and has never belonged to Timber Ridge Estates. Laura handed me a copy. This may be the most important part of the judgment, she said. More important than the money? Money gets spent. This corrects the story wherever Brenda sent it. I understood what she meant. A false boundary can spread far beyond a fence line. It enters sales contracts, conversations, expectations, and memories. Removing a sign is easy. Correcting belief takes longer. The final reimbursement arrived near the end of summer. I used part of it to restore the Marsh Road and replace the damaged gate with a heavier steel one. The rest went into a conservation account dedicated to the wetland. I did not want Brenda's scheme to become the last chapter in the Marsh's history. So I turned the money collected from its misuse into protection for its future. The HOA had finally paid the financial cost of pretending. Brenda still had to face the personal cost of what the records revealed. The HOA had finally paid the financial cost of pretending. Brenda still had to face the personal cost of what the records revealed. I never learned exactly where Brenda moved after resigning. In the end, it didn't matter. The lawsuit had never been about chasing one person. It had been about restoring a line that should never have been questioned in the first place. The Mercer Ranch didn't look much different than it had the morning I returned after my father's funeral. The cottonwoods still framed the marsh. The old duck blind still overlooked the open water. The boundary posts still marked the same line they always had. The difference was that no one argued with them anymore. One afternoon, Sheriff Mark Dalton stopped by while checking neighboring properties. He leaned against the new gate and looked across the marsh. "Quiet," he said. "It is." He smiled. "Funny how often that happens after the paperwork catches up." I laughed. I spent 30 years reading surveys. And now I appreciate them a lot more. Before leaving, he looked once more at the Mercer boundary marker standing beside the road. "Most people think property disputes start with fences," he said. "They start when someone decides the record doesn't matter." His truck disappeared down the county road, leaving nothing but the sound of wind moving through the reeds. A week later, Laura Bennett mailed me the final certified copy of the judgment, with every appeal deadline marked complete. Across the first page, someone had stamped a single word: "Final." I placed it inside my father's filing cabinet beside the original deed, the county plat, the survey, and the photographs from that first morning when I found strangers hunting from our blind. Those documents told the entire story without emotion. A recorded deed, a false map, a certified survey, financial records, emails, a court order. None of them raised their voices. None of them needed to. Months passed. The conservation work continued. Migrating ducks returned in larger numbers after damaged shoreline grasses recovered. The repaired blind became part of the landscape again, instead of the center of an argument. Walter Hayes still stopped by for coffee every few weeks. One morning he looked across the water and said, "Your grandfather would recognize this place." "My father would too." Walter nodded. "They'd both be proud you protected it without trying to punish anyone." That was the part I hoped people remembered. The victory wasn't that the HOA lost. The victory was that the truth no longer depended on who spoke the loudest. It depended on what could be proven. On the first morning of that next duck season, I walked to the blind before sunrise carrying the same thermos I had brought nearly a year earlier. The marsh was still. No ATV tracks crossed the grass. No laminated permits hung from windshields. No one waited to tell me the land belonged to somebody else. Mallards settled gently onto the water as daylight spread across the reeds. I sat quietly and watched them for a long time. My grandfather had trusted the land. My father had trusted the record. When my turn came, I learned they were trusting the same thing, because land can be misrepresented. Maps can be redrawn. Stories can be repeated until they sound like facts. But sooner or later, every claim has to stand beside the deed. And when that day finally came for the Mercer Marsh, only one story remained standing, the one that had been recorded all along.
If this story proves anything, it's that the truth doesn't become stronger because people argue louder. It becomes stronger because someone takes the time to reassure it. Daniel didn't protect his family much by shouting, threatening, or trying to settle old scores. He protected it by keeping records, respecting the law, and refusing to let assumption replace facts. Sometimes the quietest decisions, serving the deed, keeping old surveys, documenting what you see, become the ones that matter most years later. That's a lesson worth remembering, whether you're protecting a brand, a family home, or simply standing up for what's right. There's something reassuring about that. Real justice isn't always dramatic. Sometimes it's simply the moment when the truth is finally allowed to stand on its own. And when that happens, what truly belongs to you doesn't need louder voices. It only needs honest proof and the patience to see things through. I'd love to hear from you if you ever deal with an HOA dispute, a property line disagreement, or have to rely on paperwork instead of opinions. Drop a justice in the comments or simply comment once if you believe standing your ground the right way is always worth it. And if you enjoy stories about ordinary people protecting their land, their right, and their peace through determination and the law, I'd be honored if you subscribed. There are plenty more stories waiting just down the road, and I'd love to share them with you.